Hi, and welcome to Beverage Trade Network webinars. We've got Ross Appel here from Komlossi Law, and he'll be talking on beer franchise law for the craft beer industry. I'm going to let Ross introduce himself. So without further ado, here's his webinar on beer franchise law.
Thanks, Zach. Appreciate the introduction. Appreciate you having me here today. Again, my name is Ross Appel. I am an attorney with Komlossi Law. We are located in Hollywood, Florida. For a frame of reference, that's somewhere between Fort Lauderdale and Miami. We work on small business matters with a focus on, at least for myself, we work on all sorts of small business matters, and I have a focus on beer law and particularly the craft beer industry. Generally includes everything from starting up entities, key contracts, internal documents, intellectual property protection, licensing, and more. I'm also a director with the Miami Brewers Alliance, a nonprofit down here. Real quick, going over the contents. In this webinar, we'll discuss the beer franchise laws, which will include a look back to the history of beer franchise laws, the nature of the industry that led to the implementation of these laws. I'll discuss things to consider when you're starting a brewery or otherwise expanding the distribution of your brewery into a franchise state, and how that may impact your distribution contract or contracts. It's a relatively common misconception for people to believe that beer franchise laws date back to the time that immediately followed prohibition. Most outdated beer laws are just kind of flippantly referred to as prohibition-era, but that's not so much the case, especially as far as franchise laws are concerned. For the sake of clarity and background, I want to go back a bit and talk about the history of how the franchise laws came about. Started, obviously, I'll go back to prohibition and the start of the three-tier system of distribution. As the repeal of prohibition neared, John Rockefeller Jr., who at that time was a leader of the temperance movement and generally just a ridiculously wealthy guy, commissioned an attorney and an engineer to study alcohol regulation, provide guidance and recommendations that the states would potentially use following the passage of the 21st Amendment, which, as you know, ended prohibition. Their report generally focused on the tied house, the relationship where a manufacturer controlled a retailer, and the belief that bars, or back then saloons, were evil and ruining the communities they were in. The report was called Toward Liquor Control, and it basically determined that the most important thing to the new system of alcohol control was that the laws would seek to prohibit all financial ties between manufacturers and retailers. And from that, the three-tier system was born. However, it wasn't until the 1970s and 80s that the franchise laws were born. You had a few examples. A lot in the 80s. You had Texas, some of the big states. Texas in 1981, Florida was 87, North Carolina and Oregon were at the very end of the 80s in 1989. So basically, these were a creature, if anything, of the beer industry landscape at the time. And that was basically based upon industry consolidation. In the late 1800s, as you can see in the little chart on the screen, the number of breweries in the country was well over 2,000. Most of them were small, producing 4,000 barrels or less. Big breweries dominated. Best Brewing, Hellgate Brewing were a couple in New York. They were doing over 200,000 barrels of beer each year. There were a bunch of Philadelphia. They were basically generally in the bigger cities. You had Schlitz also, Anheuser-Busch, of course, and Pabst. Following Prohibition, the number of those breweries operating in the country dipped well under 1,000. Continued to drop following World War II, and again, that was due to consolidation. The number of breweries dropped below 700 in 1940. This is on the chart on the screen. And under 300 in 1955. It continued to drop, and by 1980 there were about 100 or 101 breweries in the country. Whereas 1940, the 5 largest breweries were limited to a market share of 19-20%. Once we got to 1980, the 5 largest breweries controlled 3/4 of the market. They dominated the market, and that's not terribly different from where we are today. By the 80s, the number of breweries in the country was at an all-time low. You had 41 companies operating just 89 breweries. Because the industry was so concentrated in only a handful of enormous companies, the independent distribution tier struggled to remain independent and was generally without leverage when one of the mega breweries gave marching orders. Basically, if a large brewery told the distributor to take certain actions, or sometimes it was to refrain from certain actions like distributing competitor brands, the distributor was generally at the supplier's mercy. It was fall in line or basically lose your cash cow, or ultimately completely lose your business. So it was with that backdrop that the franchise laws were created at that time to protect the small distributors. Essentially, again, with that purpose of protection, it was kind of going to provide influence to this group of distributors that otherwise had little or none. They could use that influence or leverage when either contracting with the larger breweries or perhaps in the political process to establish something there on that end to further the franchise laws, which already were a legislative creation that was absolutely enormous for the power that they have, and actually the power that they had back then, and of course the power they've got now. Without that power, that legislatively created power, those mega brewers could basically threaten to terminate a distribution agreement whenever they wanted. Distributor could work to grow the brewer's brands, and then the manufacturer could warn that it would take its brands away, and the goodwill that was arguably created by the distributor, depending on the circumstances, and bring it to a competitor, or at least threaten to change prices. Even where the growth and goodwill wasn't necessarily attributable to the distributors, those distributors were investing in their businesses and were completely at the mercy of mega breweries. So even if they were putting enormous investments in their business because of what was coming their way and because they were signing contracts with the large breweries, if not for those contracts, those investments go away. And if they were to lose the big brewery, those investments would be entirely in vain. So again, the laws were amended to ensure the protection of the distributors, which, somewhat interestingly enough, now that's the protection they fight against when it comes to the craft beer industry. So now looking at how things have changed since these franchise laws came to be. As you know, the bargaining power and the landscape of the beer industry has changed significantly since the 70s and 80s, where the largest manufacturers dominate market share. There's now more than 4,000 breweries in the country, so market share is still similar, but you have an enormous amount of breweries that this just doesn't logically apply to any longer. The fact that for example, the fact that the distribution lobby is so strong in the political process demonstrates that the middle tier no longer needs this legislatively created bargaining power, or at least as far as it relates to the craft beer industry. This past year, for example, there was a proposed bill in Florida that sought to reform the beer franchise law and make it more reasonable as far as it applied to just small breweries. But even before that proposed legislation had its first hearing, legislators had already agreed and promised the distribution lobby to wipe that portion of the proposed legislation from the bill. Basically, the first hearing on the bill it just included a confirmation that they would take that out of the bill altogether. So the fact that these things are so difficult to modify because of the strength of the distribution lobby shows that they're not necessary. Moving on here. Again, just kind of the background on what they were supposed to do and the spirit behind the franchise laws. where they once worked to protect the little guy who had little to no bargaining power, which was the distributor, against the giant brewery with everything on its side. Now they work to protect the big company with all of the bargaining power that doesn't need this somewhat artificial protection, and it protects them from the little company that it doesn't need protection against. It's a little company that had no leverage whatsoever anyway, and if they had any leverage, it's gone anyway because it's been artificially removed by the nature of the franchise laws. And ultimately, once you're in with a distributor, the franchise laws make it incredibly difficult to find any reasonable way out. With that, let's move on to the laws themselves and some things to consider when operating or getting ready to operate in a franchise state. I guess we'll start logically with the definition of a franchise, or at least a franchise as it applies in the beer context. And generally, whether they call it a franchise or otherwise call it an agreement, the laws follow a similar pattern from state to state. A franchise is basically just a contract or an agreement. It can be express or implied, it can be oral, it can be written, and basically just a manufacturer grants to a distributor the right to purchase, resell, and distribute any brand or brands offered by the manufacturer. There are some distinctions between your usual franchise, or what you know as a franchise when you consider things like a McDonald's or something like that, and a beer franchise in a legal context. Usually, the franchise, you see, the franchisee is given the right to sell or distribute goods or services that bear the franchisor's trademark. The franchisor has significant control over the method in which the franchisee operates, and you see payment from the franchisee to the franchisor. You also see situations where the franchisee, which in this situation is the distributor, rather than whether it be some sort of a monthly payment or a royalties payment, they're doing exactly what they're doing here, which is selling or distributing goods that they're paying for from the franchisor. What you see sometimes here basically we see almost all the time in other franchises that you only see sometimes here is an initial basically franchise payment, maybe essentially a down payment from the franchisee to the franchisor just to get into the business in the first place. Moving on here, let's talk about terminating franchise agreements. Most states, or pretty much every state, requires, depending on the circumstances, requires good cause for a brewer to cancel an agreement with the distributor. Because of the nature of the good cause requirement, even though it seems logical to leave terminating an agreement for the end, I start with this because while it might seem like a final consideration, it's incredibly important to consider the good cause requirement in basically everything you do when you're dealing with this franchise arrangement. Otherwise, basically, the way out of this relationship is incredibly difficult if you have nothing written down to get you out and no ability to point to good cause, basically. No matter what the case, well, not necessarily, but more often than not, the distributor will argue that something, if it wasn't in the agreement, or even if it was in the agreement, that it wasn't a material portion of the agreement and that you don't have good cause. So while it might potentially look silly, it's always a good idea, or it's certainly not a bad idea to specify all of the important and material contract provisions with wording that will basically track the language of your state's good cause definition. So looking at that definition, good cause, simple enough, it's generally just defined as a situation in which a distributor failed to comply with a provision of the agreement which is reasonable and of material significance to the business relationship between both parties, the distributor and the manufacturer. Then there are generally notice requirements, essentially just breaching the agreement, or the distributor breaching the agreement isn't enough. So after following a breach of a material provision of the agreement or otherwise an alleged breach, the brewery generally must notify the distributor, and usually you'll see the distributor needs to be given a month or so to come up with a corrective plan of action, and then a few months after that to actually put that plan to work and cure the actual breach. So it is a potentially getting out of a franchise agreement is certainly timely and very costly. So having anything written down that refers to good cause gives you at least the opportunity to make it as efficient as possible. I mentioned above the idea of the material provision when talking about good cause. So again, always a good idea to specify the important provisions as material and as basically something that induced you to enter the agreement. So there's no argument later that even if it was in the agreement, it wasn't material, and it was just there. It wasn't one of the more important things that really caused you to get into the agreement. As far as these things are concerned, you'll want to consider everything important to you, small or large, everything you want from the distributor, and work from there to make sure it's in your franchise agreement with the distributor. A few examples that I cover here. Quality control is one. You'll, more often than not, you'll get a vague provision in a form agreement from a distributor, and it'll say something about requiring the distributor to maintain clean facilities, maintaining the necessary capacity to meet the brewer's inventory, storage, and vague quality control requirements. Actually, referring to the quality control requirements while not specifying what those are. Which again, the more vague that it is, the more in favor it is for the distributor. So some more specific things to consider are things like inventory control, making sure that your goods are going in there and taken out first in, first out to ensure that your products aren't getting old in the warehouse. Again, in parentheses, you will want to consider, of course, specific instructions based on the type of beer we're talking about, because if it's not something, it might be something that can age just fine, and you might as well, so long as quality, the refrigeration is good and everything's good with the warehouse, it might be better that sits in their warehouse instead of taking space up in yours. So it will depend on the brand, and of course, if there's some IPAs sitting around and they've already been in there, you want to make sure those are coming out first. Marketing and sales volume, for example. Again, another kind of straightforward thing you'll see in a form agreement from a distributor will generally say they'll use commercially reasonable efforts to develop and maintain a market for the brewer's products. Again, you want to be more specific. You might include specific sales and distribution goals. In that sense, you might want to talk to other brewers in the area, ask how their brands are doing, what they're selling, and the like, and go from there, so you know what's reasonable when setting potential goals. To that end, also performance measures and even creating a marketing plan. The marketing plan could either go in the agreement, or you can refer to it directly in the agreement to ensure that you basically incorporate it into the agreement by reference. Sales volume kind of fits in with the marketing and the sales/distribution goals, and you'll see states handle that in different ways. I put a couple examples here. Georgia, for example, they state specifically that failure to maintain sales volume that is reasonably consistent with other wholesalers of the brand is a justification for terminating an agreement. It's straightforward and it's simple, but it's something to keep in mind, so that if your goals are not being met, that's something to point to for trying to terminate. In California, they've held that the failure to meet a sales goal or a quota that's not commercially reasonable under prevailing market conditions is not reason to terminate a wholesaler, which to some extent you can see where that makes sense. If it's not reasonable, then so be it, but if you as a brewer sit down and you agree together with a wholesaler to set difficult goals because that's what you're looking for and that's what they agree they can do, then even if you get to a point of trying to terminate in California, you're not going to be let out of that contract. The court would rule in favor of the distributor. Another place that can generally provide some form of leverage or otherwise at least give you an opportunity to potentially test the efforts of the distributor without signing everything away is what brands you provide to the distributor. Most contracts you will get, and I've mentioned this a few times, you'll usually get some form contract from a distributor. They probably won't just ask you to submit a contract, otherwise they'll probably just do it with no contract at all because that also favors them. But because in that situation, you're just falling back onto the favorable franchise laws. But you'll generally get a form contract, and they will usually begin with the assumption or hope that you're going to give all of your brands and your future brands and basically everything you manufacture to the distributor. But you do generally have an option to provide the brands of your choice. Of course, not totally up to you. They've got to be brands that distributors and retailers are going to want to sell and that are going to sell. But this way, if you start by not giving away all of the brands and everything that you will brew in the future, if you don't like the services offered by the distributor that you've contracted with, at least you have the opportunity to bring other brands elsewhere, or even use the idea that you will bring those other brands elsewhere as leverage to get better service out of a given distributor. You see somewhat often there's an assumption, and I think it's something that the distributors will prey upon, and that's that they are supposed to get the rights to everything you produce. But again, that's not the case. Some language I've got here. Florida, for example, the agreement, right out of the Florida statutes, the agreement may apply to all brands or may apply to one or several brands, so long as each brand is covered by an exclusive territorial agreement. So you can't be giving away the same brand to the same distributor in the same area, but you can give brand X, you can give your porter to distributor X, and you can give an IPA in the same territory to distributor Y. Ohio is another example. The language there reads, if the manufacturer manufactures more than one brand of beer, the manufacturer may assign sales areas or territories to additional distributors for the distribution and sale of the additional brand or brands, so long as not more than one distributor distributes the same brand or brands within the same area or territory. So essentially means the same thing, and that's the norm. So while you will usually see a hope that you will give away everything you're going to produce, it's not necessary, and it's a way to keep some sort of leverage. Some states, Michigan and Virginia are some examples I have here, they require brand extensions also go to the same distributor. So brand extension is generally defined as any brand which incorporates all or a substantial part of the unique features of a pre-existing brand of the same supplier. So you've got breweries out there who will create a given line of products and, for example, give them different treatments. So it's the same beer with different treatments and selling them selling them based on the idea to keep people interested in that same product. Uinta, for example, with their Crooked line, everything that they've got, that's not the example of different treatments, but there's a line of beer where it is clear those are brand extensions. They all share actually the same overall brand. So in that situation, you want to, if it's not required, like it is in Michigan and Virginia, you want to consider explicitly not giving up brand extensions if you're in a state that doesn't require you to do so, or certainly at least consider what you want to do there. Otherwise, you're ultimately giving away all of these beers that you haven't produced yet You might never produce, but if you do produce them, you're giving them away essentially for nothing more from the distributor. Another relatively obvious thing to consider is payment from the distributors. How and when will you get paid? You should specify basically that payment will be made to you within whatever number of days following receipt of your goods. That way, if it's otherwise, they basically default to a reasonableness standard, which, so long as you get paid and it's not ridiculous, things are kind of good. You'll see people go 10 days, 15, 20 days. Distributors will usually put in there, they usually start more often than not with 30 days and give themselves a month to pay you, but probably something you should try to bring down a little bit so you're able to, while you're turning over products, you can also turn over revenue as well. Ultimately, this way, if it's also specified in this way, if payment's not made in that timely fashion, you have a reason to provide notice and then reason to move forward toward terminating the agreement. It's a good idea to provide notice of late payments as soon as possible so you can basically create a record, put everything on paper so that you have proof that these things aren't happening in a timely manner. Also, you want to specify your preferred manner of payment. That might be by check, it might be by wire, it might be neither, it might be both or either. But there might be a few things you don't want, so you should specify those as well. Usually, if payment is not timely and the distributor doesn't cure that lack of payment within what is usually a shorter notice period than with other good cause reasons for termination, again, you will have an opportunity to get out of the agreement. Moving on here, another thing to consider is, what if your distributor tries to sell or transfer its rights to your franchise arrangement? You'll want this situation to be as transparent as possible so that you can figure out what impact it may ultimately have on your business. State laws usually say a distributor does not have the right to sell, transfer, or assign the franchise without the consent in writing from the manufacturer, but will generally add that consent can't be unreasonably withheld. So you get into a question of what it means to be unreasonably withheld and trying to make sure that language like this doesn't ultimately mean that you need to basically rubber stamp any sale of your franchise or any transfer of your franchise by the distributor. That's something that being consistent throughout your arrangements you have with different distributors is important. That way, if necessary, upon a transfer or sale of your franchise, you're able to demonstrate that if you're withholding your consent of a transfer based on the given circumstances in that situation, that those circumstances are reasonable based upon what you usually look for in a distributor. Again, you see on the screen, I think, you'll usually see things that might include, it's what's important to you, but something like specifying the importance of craft beer sales experience, which I would go beyond just saying that, because again, when things are vague, they're not terribly helpful. So that might be the transferee or assignee or the purchaser of the franchise having at least 3 years, for example, selling the brands of at least 3 different craft distributors who are producing less than 5 or 10,000 barrels of beer per year. But something like that that's specific, that shows that sales experience of craft is important to you. The other thing might be resulting market combinations you don't approve of, which could basically be when a couple of, if you don't want to be a part, for example, of the Anheuser-Busch distributors, if there's a merger there that leaves you with no choice but to be a part of it, and it significantly changes that landscape of what's going on in that territory, you might be able to provide for yourself a way out by ensuring that that's in the agreement and that it's generally present in all of your agreements so that it is reasonable and it is something that is important to what you do and what you're looking for with a distributor. To the next slide, don't be fooled. A lot of these form distribution contracts will be either so incredibly vague or incredibly short so that it makes them completely meaningless. You might also see some contracts that will include things, or you might be told that either party can cancel at will, which, again, somebody can tell you that you can cancel your contract, no strings attached if you prefer, but that isn't going to make it reality, even if it's in writing, even if it's signed by the distributor. The law in each state generally notes distributor can't waive any of the rights granted in any of the provision of the franchise section of the law. So a contract might say that, again, the brewer can terminate at will, but it's essentially a red herring that would be unenforceable, and it takes your attention from including legitimately enforceable provisions for termination in the agreement. Again, a vague contract works completely in the favor of the distributor. If you want a potential chance to fight your way out of an agreement that isn't working out for you, you're going to need it in the contract. Again, because of these anti-waiver provisions of the law, provisions that might actually seem favorable to the brewer, they're completely unenforceable, and your contract would just default back to the distributor-friendly franchise laws. So if you see any of these in a potential agreement for you to sign, if a distributor tells you, don't worry, our word is our bond, we'll honor the contract provision no matter what, that's fine. Go ahead, let them leave that in there, but you still need to add well-written termination provisions as backup, because again, if that distributor changes its mind, that way you would have a fallback option. Otherwise, if the distributor decides later, yeah, you know what, I don't like what I've entered into here, and you have nothing else except for saying they told us they would get out of it, they even signed saying they would get out of it, the law says, except for in limited circumstances, which we will talk about later in just a bit, the law says you're stuck. The distributor wins, despite the fact that they've agreed otherwise. And really, if a distributor says no to adding legitimate reasons to terminate a contract while also telling you they've got no problem letting you cancel without cause, then there's something wrong with that picture, and there's something else going on there where they just probably want to make sure that things that are actually helpful for you won't be included in the agreement. Moving on here. Talking real quickly about fair value might be another thing to consider in a distribution agreement based on the franchise laws, where when a brewer terminates an agreement and it's not with good cause, the brewer generally will have to pay the distributor who's impacted by it, or their distributor, the fair market value of the distributor's business, including the distribution rights, which have been lost or diminished as a result of the termination. Defining fair value, it can be a tough thing to do especially at a very early stage, whether it's an early stage for the brewery or even just an early stage in a relationship between the brewery and the distributor. It's tough to come to an agreement there, but it's something to consider. Otherwise, you get into a spot where down the road you're in an incredibly lengthy arbitration or litigation process. It's lengthy, it's incredibly expensive just to figure out the amount of money that it takes for you to get out of an agreement. And I guess definition of fair value, getting to that real quickly. Kind of a vague thing. It's ultimately basically what someone would pay in the free market for the right to distribute your products at any given time. So, again, if it's not defined in the agreement, you should look for a way to define it. It'll usually be a multiple of sales revenue of the brands, generally looking back at the immediately preceding 12 months. I mentioned just a bit earlier, there we go, who might be exempt from franchise laws. This is a big slide. There's a lot on this slide. I may have gone too far with putting everything on one slide here. But generally just a few examples of situations where some breweries are exempt from franchise laws. And basically, these come just like in the 70s and 80s, legislators figured something needed to be changed because of the relationship between the giant businesses and the small businesses. Some states have at least figured out that the purpose of the franchise laws and the spirit of those laws don't properly apply anymore to the current beer industry landscape, or at least to the craft landscape. So they have exempted smaller breweries from the franchise laws. In these states where a contract will, if a contract governs the relationship between a brewery and a distributor, the terms of that contract are going to be very important because the franchise law doesn't control, the contract will. So there's no default franchise law to fall back on. So whatever you're putting in the contract, that's going to control that relationship. Colorado is an example. There, the franchise law doesn't apply to a brewery that produces less than 300,000 gallons of beer per year. It's about between 9 and 10,000 barrels or so, probably a little closer to 10. And Nevada's another. They exempt breweries who sell less than 2,000 barrels of beer per year. And Utah exempts small brewers, which it defines as manufacturers producing less than 6,000 barrels per year. Another thing that's difficult to consider, but incredibly important, this is where your imagination comes into play, is the future. You want to think about the future. You want to consider things that might one day be important to you in your business. An example I like to use is self-distribution, where you still have a few handfuls of states that don't allow breweries to self-distribute. So in that situation, you want to consider including a provision that allows you to terminate for good cause or otherwise modify the agreement for good cause if self-distribution becomes legal. In a situation that legislators do, and basically if and when, because I imagine this will happen everywhere at some point in the few, again, the 13 states or so that haven't done this, but when states who don't allow self-distribution ultimately change that law, they're not going to allow breweries who are already tied to distributors to self-distribute where they're already signed. So you might want to include something, for example, modifying that allows you to modify the territory served by the distributor. That way you can self-distribute in what was a portion of that territory, or something that will allow you to terminate the agreement so you can distribute your products on your own. Again, it's a negotiation. Distributor might certainly have an issue with the latter portion of that potential change. Another real quick thing is, before we move on to this slide, some states don't require exclusivity with the distributor, but even where that's not required, you still need to sell the brands in a non-discriminatory fashion if you have more than one distributor. So ultimately, if you're unhappy with one distributor and you have a couple of them, you can't just stop selling your brands of beer to the one you're unhappy with to basically shut them out. Then they have a legitimate way to go after you, and again, that's based on the franchise law. The tough thing there is, of course, while you can't stop selling to them to basically shut them out when you don't appreciate the way they're doing business, they can essentially do the same thing to your brand. They have the ability, basically, if you don't have a good contract, to hold your brands hostage and not reach your sales goals. And there's really nothing you can do, and no real way out. Moving on, this might be the last slide. We're getting close. signing bonuses is another important thing to consider when you're expanding, where your reputation is already known into either where you're expanding or even if it's your hometown and you've only had your tap room open, so now you're starting to distribute. If it's legal, you want to seek a signing bonus. Obviously, anything you can get, you might as well get. Otherwise, you get yourself into a situation where the distributor has the ability to hold you hostage, but also the ability, if they want, to sell your rights to another distributor and make money with you otherwise getting absolutely nothing for the rights to sell the beer that you're producing. It doesn't really make sense. And in that vein, Texas is an example right now. They have a pending lawsuit based on 2013 legislation a couple years ago, which altered their beverage code and prohibited any manufacturer from accepting payment in exchange for an agreement, setting forth territorial rights. So basically, you could not get paid when you were signing with a distributor for the right to sell your beer. It's the constitutionality of that legislation is being challenged. It'll be interesting to see where that goes. Ultimately, it's important to make sure it's legal, but you want to get whatever you can for the value of what you're giving up. And in many states, you can get a signing bonus. There are certain things you can't do. Usually loans or direct interest in the business are issues, but here's a situation where you're giving up something of value. Normal contract, common sense, and but the law will generally allow you to get something of value when you give up something for value. Otherwise, you can't really even have a valid contract.